Okay, thank you for your patience and sorry about that. I've been on since 10, 15 or so, just wondering what was going on. Okay, we've got the matter of CMR versus Payung. I may not be pronouncing that correctly, but Mr. Blunt, you filed a notice of non-jury trial about 37 seconds after the last pleading was filed, and I thought, rather than set a pretrial conference with a ton of formality, I just set a status and see what's going on. I can set a pretrial conference promptly if you all really are ready for the trial. But in my experience so far, that has proven to be a waste of time. So let me just find out what's going on. Mr. Blunt, are you really ready for trial? And do you want me to set non-jury trial 30 days from now?
I think so, Your Honor. And Mr. Knipe and I have discussed it. It's a fairly straightforward matter, and Mr. Knipe and I have worked together before, by the way, Your Honor.
Okay.
And always worked very cooperatively with one another. And the way we see it, there are really only two primary issues in the case, and that is one, whether or not my client wrongfully evicted Mr. Knipe's client by going in and changing the locks a couple of days beforehand, before the end of the term, after a phone call. And the second issue being, was there damage to the property? And as a sub issue to that, was the damage to the property caused by the tenant, or was it pre-existing? So we think it's fairly straightforward. And as a matter of fact, just this morning, Mr. Knipe and I got on the phone together and discussed the possibility of whether or not we want to do a stipulation to go to binding arbitration.
Okay.
In order to simplify it even more. We just don't think there's enough money at issue to make this complicated, to do a bunch of depositions, to do a dragged out Zoom trial, et cetera, et cetera. If we could get together with somebody like Judge Hart, we could probably proffer this thing in 2 or 3 hours and put it to bed. But I think at least lawyer to lawyer, we kind of agreed that would be a good solution to this problem. I don't know if Mr. Knipe has had a chance to discuss it with his client. I've had a chance to at least pose it to my client through my staff, and I'm told that my client is likely agreeable to that avenue.
Okay.
We didn't think non-binding arbitration was a good idea because the problem we have with these clients, Your Honor, is it's not a lot of money. Both clients are extremely acrimonious to one another. I will tell you, I am 100% confident Mr. Knipe has made every effort to get his client to be reasonable and settle. And I think Mr. Knipe would tell you the same thing about me. This is one of those cases where neither one of us want to be here, Your Honor. We both are telling our clients, stop it, stop it, stop it. And our clients are saying—
Thank you both for not getting in the mud with them, because I see that all too often.
We will not do that. And I, quite frankly, Your Honor, without waiving any attorney-client privilege, I've advised my client that he should go to non-binding arbitration, or binding arbitration, I'm sorry. And let's get this done the quickest and most efficient way. And I'm hopeful that Mr. Knipe's client agrees to that, and we get off your docket and go to Judge Hart and let him submit something to you to enter as an order.
Well,
as a final judgment.
I certainly appreciate the speed with which both of you have gotten to this point. Like I said, 90+% of the time, probably 99. I get a notice and everybody goes, well, we still have to do about 40 things. But it sounds like you all are able to bring this to a head. Now Mr. Blunt, you're on behalf of defendant and also you're a counter plaintiff, right? We've got a counterclaim?
Correct, Your Honor.
All right. And then is it Knipe or is it Knipe?
It's Knipe.
Knipe. Okay. I figured you all have worked together before. Mr. Blunt probably had that right, but I wanted to verify. Mr. Knipe, do you differ in any way with the synopsis Mr. Blunt just offered?
Not in any way that really matters.
Okay.
I haven't had an opportunity to, like Mr. Blunt said, we just talked about it this morning, probably maybe 45 minutes ago.
Okay.
I represent a non-natural person entity and two of the people that were tenants in this location, and I have to talk to all of them, and they live in different time zones. So I would love to deal with this via binding arbitration, because I think that I think there might be a few issues of factual dispute, insofar as, whether or not someone was making a representation about whether they intended to leave the premises and whether there was an effective, that would have justified his client going into the premises early. But I think that those are the sort of things that might be able to be resolved in binding arbitration, insofar as maybe there's some type of, instead of just proffering testimony, that there would be some sort of live testimony with regard to that, to allow the fact finder to make a credibility determination. But I don't think that this, I can represent to you, Your Honor, that we have propounded discovery upon Mr. Blount's clients that is coming up due here in a little bit, and he represented to me on the phone that it was his intention to propound some discovery upon us as well. So I don't think that this thing would be prepared to go to trial in 30 days anyway, because I think we would want to be able to have an opportunity to provide discovery to Mr. Blount, and I would imagine he would want some time to review it and discuss it with his client.
Okay. Well, what can I do to help? I guess, tell me how this court can be most helpful to the two of you in one, wrangling your clients, and two, sort of calling the question. I'll put the question to you first, Mr. Knight.
I would suggest that Your Honor enter a pretrial order for probably about maybe 2 months from now, with a trial date to be maybe a month and a half after that, or something along 2 months after that, with the understanding that, and I will be contacting my client and suggesting to them that we do some type of binding arbitration to resolve this, because it would be the most cost-effective way of resolving what is otherwise not a high dollar value dispute.
Yeah.
And that way, in the event that anybody decides that they want to have their constitutionally protected right to a trial in front of Your Honor, that at least we have something's on track to get us motoring in that direction. Okay.
And is it necessary or helpful for me to actually order the binding arbitration, or is that something that you all are reasonably comfortable that you would be able to stipulate to and take yourselves to?
Well, I'll tell you right now that if my clients are agreeable to it, Mr. Blount and I will get it worked out. You don't need to send us something.
Yeah,
we're both big.
If we can agree to it, Your Honor, we'll prepare a stipulation and an order so that it is directed by the court and so that you're aware of it. And if that happens, of course, then we wouldn't need any more pretrial anything, because we're going to binding arbitration. And I don't have any strong objection to the timeline suggested by Mr. Knight. I think we could do it faster, but appreciably, and I anticipated, Your Honor, in filing my notice for trial, given my experience thus far in county court, which is not great, that we were probably looking at a trial date in March or early April when I filed that notice. Heck, I can't get a 15-minute hearing before Judge Hayes until June. So
yeah. Well, I didn't know if your comment that your experience in county court is not great is because it's not
limited,
not
small.
Numerous, or that it's low quality.
No, not numerous, Your Honor, absolutely not.
No, and I'm sure that was part of the legislature's calculation in shifting our jurisdiction, which I think was long overdue. But we do pride ourselves, at least I pride myself, in trying to be reasonably agile to get parties into court quickly when necessary. But like I said, sometimes I'm too quick on folks, and they wave me off pretty quickly. But so, Mr. Blount, to clarify what you said a moment ago, Do you all want me to go ahead and schedule a pre-trial conference now that would happen in a few months, and you all try to do arbitration between now and then, and you can cancel me if you don't need me? Or do you want me?
Yeah, that's what I would suggest. Schedule a pre-trial conference in 30 to 60 days. That allows us to put some pressure on our clients and say, hey, this judge likes to go fast. She's going to give us this pretrial conference, and at this pretrial conference, she's going to set a date about 45 days after that, maybe 60 days at the most, and we're going to be going to trial, and this is going to get expensive very fast. But Mr. Knipe and I would suggest this alternative way to get this thing through to save you guys some money. See if we can get them to agree.
And what kind of time does it take you once you agree to do arbitration? How quickly can y'all get that onto a calendar? Is it faster than we are?
Yeah, I think it depends on the arbitrator's calendar. My experience has been that, when in doing either non-binding or binding arbitration, once everybody sits down and agrees on, who's going to play Solomon, that Solomon gives everybody a telephone call and tries to set up some, rules everyone can live by. And it's a couple of weeks maybe after that.
Okay. So I didn't know if it was your intention, and I can set a pretrial conference for really any time, but I didn't know if it was your intention to try to get the arbitration done before the pretrial conference, or if y'all want me to have a pretrial conference and you would try to get the arbitration done between that and the trial.
I would say that if once we get done with this hearing, I would imagine that you, at least in my mind, what I'm thinking is that you issue the pretrial order, and within the next 24 to 48 hours, I'm going to be calling up my clients and sending them an email, giving them a rundown of what happened this morning and making my suggestion about binding arbitration. And either they'll have to think it over for a little bit, or they'll be able to give me an answer on the spot. And I'll just tell Mr. Blunt, like, it's X or it's Y. And, if it's we're going to be doing arbitration, he and I are going to put together some type of, we'll have to agree on who the arbitrator is, but we'll put together some type of stipulation, that arbitration will occur in the next 45 days or, something like that.
Okay. And so is that why you were suggesting the pretrial be set out maybe something like 60 days?
Yes, ma'am.
Okay. I just want to give you enough time. I'm happy to set a hearing, and I very much appreciate that the scheduling of a hearing opens up the ability of you all to apply appropriate pressure on clients to start to make some decisions. But I didn't want to set it sooner than would be helpful or farther out. So I'm fine with, 60 days out. I typically set 30 minutes and send out a standard pretrial conference order that requires both sides within a period of time, I think 10 days or something, to exchange, witness lists and exhibit lists, simple stuff like that. So I can certainly get that order produced pretty quickly, and it'll go for a date in about 60 days. It'll indicate that the non-jury trial, estimated to last 1 day, will be scheduled at the pretrial, and that'll give us a little bit of structure to the conversation. Is that about what you're suggesting, Mr. Knipe?
Yes, ma'am.
Mr. Blunt, any adjustments you'd make to that plan?
No, ma'am. I think that's perfect. And I think before that pretrial, you will either receive a stipulation from us that says we request you cancel the pretrial since we are going to mediation, or you won't, in which case we know we're going to trial.
Okay. You mean arbitration, but I follow.
I'm sorry. No, I'm saying if you don't get a stipulation, then we will be going to trial with you, and we will need the pretrial conference, right?
Right. So we'll have it all set, and that way you don't have to regroup if the arbitration idea falls through. You've already got a date that's quickly approaching. All right. Well, I will do that then. I will get a pretrial conference order out and remain available for whatever you all might need. I'm extremely appreciative of the collaboration and professionalism that you've demonstrated so far. It's all too rare, but very much appreciated. So keep it up, and don't hesitate to let me know if I can help keep things moving smoothly for you guys.
Thank you very much, Your Honor.
Thank you.
Okay, you all are set to go, and I'm going to be in just a brief recess until our 11 o'clock. Okay, good morning, everyone. Welcome to Collier County Court. I'm Judge Martin. We've got a matter, two matters at 11 a.m. I'm going to call, I think the one that should be a bit shorter is Lussier versus Hinderman. Do I have parties on that? Counsel for Lussier?
Yes, Your Honor. Colette Keller-House Wright for Mark Lussier.
Lussier, okay. And that's Ms. Keller-House. All right, is there anybody for Mr. Hinderman? Let me switch files and get that up. Ms. Kellerhouse, it looked like you all got personal service December 1st. Do I have that correct?
I believe it was December 1st. Yes, Your Honor. I have it on my notes as December 2nd. That could be the date of the e-filing of the return. However, it was personal service by our process server, and the order's been delivered. And, you know, typical of Mr. Hinderman's conduct in this case, he's not appeared. So we would just be asking the court to enter writ of bodily attachment at this point.
Okay, I will ask the obvious. There's been no compliance or contact of any kind since he's been served with my order to show cause?
No, I've never actually had any contact with him whatsoever, despite the various services of documents upon him.
Okay. So no compliance or contact, and he has not appeared this morning. I imagine everybody on right now is on for the Heritage Greens versus O'Donnell matter then. All right, and so this is all over a fact information sheet, is that right?
Correct, Your Honor.
All right. Well, I guess we can do this two ways. I can do an order, have you send me an order that fines him in contempt for failing to comply and failing to show today, and gives him 10 days to purge himself of that contempt, or face a writ of bodily attachment, which would be issued without further notice or hearing. If he hasn't complied, I would just ask you to forward that writ with a cover letter that indicates there's been nothing from the order finding him in contempt, and then I would issue the writ. That's probably my preference, to make it a two-step as opposed to just issuing the writ right now. And as I'm sure you're aware, the sheriff's office always reminds us to ensure that that writ has all the appropriate information so that they can identify Mr. Hinderman, you know, whatever, white male, address, date of birth if you have it, etc.
Certainly.
I think that's my preference, but I'm open to suggestion or concern that you might have with that.
Well, the only concern I have is that Your Honor did enter an order, I believe it was on August 26th of 2020, compelling him to complete it. And then if he didn't complete it, then he should be ordered to show cause. So now we're going back to the compelling or holding him in contempt again prior to issuing the writ. However, if Your Honor prefers to do this two-step process again, I would have no objections to it and will submit the appropriate orders to chambers.
Yeah, it is. I will admit it is conservative, but with a pro se individual, I think I do prefer it. Like I said, I won't require two hearings, but I think that I would ask that the order that you send me, and I think you've done a great job on this so far, so I'm sure this is what you're going to do, that the order will recite that I find that my final judgment ordered him to do it, that I've issued an order to compel that ordered him to do it, that I've done an order to show cause that ordered him to do it, and that he failed to appear and show cause today. And so based on that, I'm finding him in contempt, and will issue a writ of bodily attachment should he fail to purge himself of the contempt within 10 days.
Okay. And will Your Honor require that order to be personally served on Mr. Hinderman?
I will, yeah. But I am, you have not, correct me if I'm wrong, have you sought sanctions? Because I think it's appropriate that I would, if he's been placed on notice that you're seeking them, that I would order him to pay appropriate fees and costs associated with this. If not, you may just bring a motion for that, but it will ultimately be his expense.
Yes, and Your Honor, we did actually request that in our motion for order to show cause. That was the basis for Your Honor's order to show cause. We asked that we get the attorney's fees for preparation of the motion. So if we could just have jurisdiction reserved as to the amount, I would appreciate it.
That's fine. I will absolutely do that. It is appropriate that he will ultimately have to pay for your time and for all these service charges. But before I have him arrested, we'll have one more order that sets forth the history, finds him in contempt, and tells him he's about to be arrested. He's got 10 days to get this completed and served on you. And should that not work, then if you'll forward me a writ with a cover letter that indicates, Judge, we have not received anything, then I will issue that writ ex parte, and we'll see where that gets us.
Okay, thank you very much, Your Honor.
Okay, thank you. Have a good one.
You too.
And my other 11 o'clock, give me just one moment. I'm just going to make a couple of notes before I switch. Okay, the other 11 o'clock matter, thank you for your patience, was Heritage Greens versus O'Donnell. Can I get counsel's appearance for plaintiff, please?
Yes, Your Honor. Joseph Baer, law firm of Boatman Ritchie for the plaintiff.
Okay, good morning to you. And for the defense?
Robert Twombly, White and Twombly, on behalf of Lorene O'Donnell.
Okay, and I've got someone else. Is that just the audio for one of you guys, or is there a third party at 394-8111?
That's Jamie Grusel on behalf of Colonial Links Condominium.
Okay, can you spell your last name again for me? I can almost recall.
Greus, S as in Sam, E-L.
Okay. Great. And that's Colonial Links. All right. So, Mr. Baer, I think this is your motion to compel. Is that right?
Yes, Your Honor.
Okay. Go ahead.
Your Honor, we're here on a motion to compel response to discovery. The discovery requests were served January 30th, 2020, so almost exactly a year ago. And Your Honor, to just maybe jump ahead a little bit and then come back, we did receive a response from Defendant O'Donnell through counsel yesterday evening. I believe responses to the interrogatories were filed approximately 9 p.m. and responses to requests for production were filed at approximately 10 p.m. So just kind of goes to the modus operandi of the defendant in this matter to wait until literally the 11th hour before filing a response. We have made previous good faith efforts to compel this discovery. My firm sent a letter to opposing counsel on March 2nd, or excuse me, the original response was due March 2nd, 2020. We sent a letter to opposing counsel on March 23rd requesting the response and inquiring as to whether more time was needed. Never received a response. We then sent a follow-up October 27th. I sent a letter to opposing counsel letting them know that we had not received any response. No motion for an enlargement of time had been made, had been absolute radio silence, and informing opposing counsel that if we did not hear anything within a week, we would be filing this motion to compel. And this is where we are, Your Honor. And if I could take a moment to just address the responses that we received yesterday late last night, the responses are still inadequate, Your Honor. The request for production references several checks and money orders that defendant claims were paid to the plaintiff for the assessments now liened, but those documents are not produced. So the only documents produced, 2 checks were produced. Of course, Your Honor, I have not had time to go back and evaluate the file to see if those payments were previously credited to defendant's account due to the lateness of them being served. But as I said, only 2 checks were actually produced, and a number of others were referenced and claimed to have been paid by defendant to plaintiff, but were not. No bank records were produced to reflect that.
Mr. Baird, let me clarify, because I have 2 different defense counsel on the phone. Are these, we talking about discovery directed at defendant O'Donnell or defendant Colonial Links, or both?
Your Honor, this is all directed to defendant O'Donnell. To be frank, Your Honor, I'm not sure Colonial Links involvement or necessity to be in this hearing. I don't mind them being here, but as we say down home, I have no beef with Colonial Links at this point.
Okay, so it's just it's defendant O'Donnell and represented by Mr. Twombly. That
yes, Your Honor, forgive me for not making that clarification.
That's okay. It's in the motion. I just, between the 2 computer screens and making notes, I wanted to make sure I had it right. Okay, well, and I do appreciate actually that Ms. Grussel's on the phone, because when we finish, I'm going to have a few questions for you all as to how I have a 2015 case on my docket. So I appreciate that I've got all counsel. But let's deal with the discovery. Mr. Twombly, what can you tell me?
Sure. The discovery's late. I'm not here to sugarcoat it. I will tell you, I have an elderly client who has some, I don't want to say issues, but certainly has health issues. We had COVID. She wouldn't even pick up her phone or allow us to send a courier to get it done. It actually took the 11th hour of getting her son, who's also a lawyer, involved to get it done. And we got it done. Now, this is a little bit like the cat calling the kettle black. I seem to remember when plaintiff's discovery was almost a year old, and I said, hey guys, just get it to me. It wasn't with the motion for sanctions. And to say that there was no communication, I've not spoken to Mr. Baer, but I have spoken to Mr. Ricci. There's a big problem with their case. And this is what is caused this thing to be a 2015 that's still on your docket. The problem is this: they did not comply with the proper notices for the intent to lien. We filed a motion to abate back in March. I gave this to Mr. Ricci. Look at it, guys, you got a problem. The court cannot enter a final judgment because you have not properly followed the statute. The response was, I'll take a look at it. They did write me a letter back on something else previous, which was a different argument that we had made, but not the motion to abate. In a nutshell, Judge, what they did is they sent the notice of intent to lien and claim of lien. Attached to their complaint are 2 completely blank certificates, registration certificates that have no numbers. And just by way of what's going to a preview, you can't do that. That means it was never sent. If it's not stamped by the post office or generated by a computer, you didn't send it. Why is that a problem in this case, Judge? Because 718.116 says you can't enter a final judgment until 30 days after they comply with the statute. They didn't. And there's been several arguments regarding the other part of the statute that I argued previously. So, to say that, hey, we're diligent, we're pushing this case, they've done nothing, and they haven't even addressed a huge flaw. This case is staying on your docket because they can't move it because they're not doing what they're supposed to. But
I saw the motion to abate when I was briefly familiarizing myself with the file. I certainly haven't read all of it, but I saw that, and was perhaps naively hopeful that perhaps the lengthy delay since the motion to abate might have been because there was an attempt to go back and tag that base, which I've not studied whether that's something you can do midstream or not. There are some things like that that require dismissal and you start over entirely. I have no idea if this is such a thing, but I was hoping the delay was maybe that there was some of that going on and the notice and the time was being, was running out. But let's keep on one topic here, the motion to compel, however that may rub defendant at this time, you also concede they are late. Now you have tendered them belatedly. I'm not deciding today, I don't think I'm being asked to decide today whether any sanctions are appropriate. I think there's just been a suggestion that they might be pursued. But can you speak to the quarrel that Mr. Baer raises that, okay, we got it late last night, but I just got basically references to documents. I didn't get documents. Is that something that's forthcoming and we can resolve, or what's the situation there, Mr. Twombly?
Yes, ma'am. Thank you, Judge. So I don't think the response are inadequate. In terms of documents, flat out, my lady doesn't have a lot of documents. She had bank records. She can't find them. I can't go to her house. I mean, I was in mid-drive to Kendall yesterday with her son to see if I could get, and she's like, you're not coming in the house. So I do have the bank accounts, which I gave them. I gave them the 2 accounts where all the checks were written out of. I gave them the check numbers. I can subpoena the bank myself if I have to get them, and I might.
Yeah.
And I think this all boils down, what I believe this is all going to boil down to 2 money orders. Now, I had asked for discovery from them back in 18, which they gave me in 19, which we're going to have to revisit too, because what he didn't tell you is in his letter to me where he said, you didn't give me the discovery, is he's also addressing our discovery responses. I know that you don't think they're adequate, but we do. So we're going to have to revisit all of this. But in any event, I will get those bank records if I have to subpoena them myself.
I think you're probably going to have to. That sounds like the writing's on the wall on that one. And I don't forgive the statement, but your client's probably not going to get more capable. So waiting isn't probably helpful. Well, let me ask a smaller question than a larger question. For today's purposes, Mr. Twombly, what do you suggest that we do? And then I'll ask the same question to Mr. Baer.
I think the next thing we do is we set my motion to abate. It'll probably have to be evidentiary because I will have an affidavit from an expert who's going to say that it never got sent. And then what that does is it doesn't wipe out their case. That's what I've been trying to explain. It sets the clock. They have to issue a new notice of intent to lien and claim of lien that tracks the statute. Well, most likely you just got to serve it on her, right? Okay. And then what happens is that gives her 30 days actually to pay off any delinquency. The risk, and I think I know why they haven't done it, is because it wipes out their right to attorney's fees.
Well, but again, whatever is, and is probably not getting prettier with time. But my question was actually a smaller question with regard to the instant motion to compel. It sounds like you concede it's late, and we'll have to figure out whether there's sanctions going in either direction. But you produced it with the exception of something that it sounds like, if I'm following you, you can and will subpoena bank records in order to supplement with actual documents what you've merely supplied in terms of a reference. Is that a fair statement, Mr. Twombly?
Yes, it is, Judge. And I'll either get those via subpoena, or we're trying in the works to maybe get the son involved, or maybe he get a power and he could just walk into the bank and just have, she doesn't have a computer. She's not in this game. Whenever she needs an email, she would used to go to the public library. So it's a little loopy on our end.
It's okay. I've got family that match that description well. But let me ask this, and again, Mr. Baer, I promise I haven't forgotten about you. But Mr. Twombly, what is a reasonable timeline for you to actually be turning that over then to Mr. Baer, because you will have obtained it and you can finish off the RFP by supplying documents.
If I have to do it via subpoena, I'm going to have to, I guess they have 30 days. So to object to the bank would have 30 days to object to the subpoena if I send it. And then I have to show it to Mr. Baer unless he would waive and agree to let me send it right out of the gate without any objection, which I don't think he would.
That's what I'd like to fix, and I'll take input from Mr. Baer now. But before we talk about bigger issues, I'd like to, at a minimum, fix a timeline for the defendant to finish this off and actually get those documents. Mr. Baer, I can appreciate you're a little handicapped. I know you probably haven't scrutinized anything else. Are you aware of any other infirmity in what was supplied last night other than what it looks like we're going to have to clean up with a bank subpoena?
I'm not aware of anything else at this point, Your Honor. Like you recognize, I haven't had time to fully scrutinize. I tried to go through it this morning. And in all fairness, it's not a large request, and it's not a large production by any means. So, but to pointedly answer your question, I don't know of anything else at this point, Your Honor.
Okay, well, I appreciate that. And I also, I think, Mr. Baer, you joined this firm obviously more recently than this case.
Yes, Your Honor. Yes.
How long ago did you end up with this file?
Shortly before sending the letter in October. So I would say probably early October.
Okay.
And
well, and I certainly know Mr. Ricci and Mr. Boatman, but the turnover from one lawyer to another within the firm sometimes adds a timeline, but I have learned, Mr. Baer, that I can count on you to follow it through. So I'm optimistic that we'll get some continuity. Certainly the case is going to move to my front burner. You have got to be, if not my oldest case, hopefully there's not a whole lot of company at this age group. So you've just become one of my top priorities. I was not aware of your existence until the motion got scheduled for hearing. And I think you also further got lucky because I think you got this request for hearing through when my JA was out, because I hadn't looked at it until preparing yesterday. And normally I would have already erupted. So I would also not have scheduled the hearing. So it's probably fortuitous because she certainly didn't notice that it was a 2015 case. So what I might suggest we do, again, for the small question, and I've got another hearing that starts in 6 minutes, is that, Mr. Baer, I grant your motion to compel, that I reserve jurisdiction to determine whether there should be any sanctions, and that I require completion of compliance within a deadline that assumes worst case scenario that we've got to go through a bank subpoena. So one question, Mr. Baer, is are you willing to basically waive any objection to that bank subpoena so we can close up that timeline as best as possible? Or is that something that creates more conflict?
Actually, Your Honor, to be honest, I'm afraid that it may actually cause more delay, just what I've seen in this file, just in the time that I've had it. So I would like to see the subpoena before it goes out. I will commit to turning it around in a quick manner. Okay. I think Your Honor has seen that I have a track record of doing that. That's why I now have this file.
Okay.
So
then what timeline would that give us, Mr. Baer?
I'm sorry, Your Honor?
So then what timeline is reasonable for us to complete that? Again, assuming worst case scenario that Mr. Twombly can't get a power of attorney through the sun or something faster.
Given that the bank would have 30 days to object, and I know Mr. Twombly is going to try some other avenues before actually drafting the subpoena. So Mr. Twombly would You think 45 days would be adequate? If you think it can be done in a shorter time, please let me know.
I would say 60, but maybe, Joe, you and I could go to Kendall and maybe we could go through the boxes in her house together.
She's not letting you in. Let's not waste the gas on that. And I
wouldn't let the sun in. Anyway, okay. Yeah, I think 60, because that would give us 30. And then maybe if there's any, I'll get the subpoena out no later than tomorrow morning. So you'll have it, Joe, so you can look at it.
All right. So then, Mr. Twombly, was that then 45 days, basically that tax on 2 weeks, 30 days for the bank, and hopefully they don't use it all, but 30 days for the bank and a couple of weeks to deal with what you'd have to do on the front end and the back end to get these couple of checks into Mr. Bayer's hands.
Yeah, I'm going to get bank statements. And Judge, if the bank objects, which I couldn't see happening, then I'll just bring it to the court's attention. So we'll deal with that if it comes up.
Yeah, like I said, you're in county court, so I have to assume we don't have a huge dollar amount, but coming up on 6 years old in county court means it's going to be a high priority for me. So I'll respond swiftly if either side reaches in for assistance on something that's gumming up the works. So I'll ask Mr. Bayer to get me an order that grants his motion and compels production of anything that hasn't already been tendered within 45 days. And reserves on any sanctions. We'll cross that bridge when we come to it.
Your Honor, I would just mention that our motion did include a request for sanctions for attorney's fees and costs.
Okay, and I guess what I can address that now if we think it's appropriate to do that. I heard Mr. Twombly to be saying, there's been a lot of that back and forth. So what I don't want to do is set off a sanction war. Certainly it's late. You had to file the motion, you had to write a number of letters. So I don't know if there's any agreement with that, Mr. Twombly, or what is your thought on sanctions at this point?
No, I would totally disagree with sanctions. I think it's, I think I've practiced probably as long as Joe or longer. And I think I've written 2 sanction motions in my life and actually followed through on them. But, I don't want it to become a sanction war because, quite frankly, I think it's sort of what's the word I'm looking for? Unfair. I get it. It was late, and I'm not saying it wasn't. But you know what? What's the harm? They sat on the file and did nothing for months.
Are fees in play in the ultimate? I guess if it's a lien case, so fees are in play if everything proves to have been done correctly, right?
Yes, ma'am.
So what I'm going to do then, Mr. Baer, is this. I'm going to stick with my initial suggestion. I'm going to reserve on the sanctions. I'm not granting them or denying them, but I'm not going to level them today. I'll simply reserve on it. You can set that for a hearing if you want to pursue it, but I'm kind of hoping that maybe what I might be able to convince everybody to do, essentially I'm a new judge on this. Mr. Baer's a new plaintiff's attorney on this. Mr. Twombly and Ms. Grissel have been going the distance, but it's going to be a priority for me. If we can get things to move smoothly and get them resolved from here, then that's something that potentially will mitigate any question in any direction of sanctions, because it sounds like we could end up with motions in both directions, and I want to avoid that. So I'll reserve on that for right now, Mr. Baer, but grant you to compel, give you 45 days, encourage both sides to collaborate on trying to get this stuff done. The age and infirmity of the client, Mr. Twombly, is only persuasive to a point. And now we need to just admit that it is what it is, and either the son gets a power of attorney or we figure it out some other way. But I'd like to see this thing get moving from here. Probably what I'm going to do is set a status conference. I was going to suggest that I might in about 60 days so that this discovery issue is resolved and you all have had whatever conversations you need to have. And then I'm going to be looking at getting you all on a trial docket or whatever I can do. Are we in a jury posture here or are we in non-jury? Mr. Baer?
Your Honor, to be honest, it's been so long, I will have to go back and review.
You know what I might suggest, and I appreciate that. What I might suggest, Mr. Twombly, to get things moving here, I might set your motion to abate.
I think that's a great idea, Judge. I was going to put it on the motion calendar, but I think it should probably be special set and give us a little time because I'm going to have an expert affidavit, and I imagine they'll probably try to get one as well.
What sort of time do you think you need on the motion to abate?
I would say 50 minutes. I mean,
1-5?
1-5, yes, ma'am.
Okay. Mr. Baer, what are you thinking on that?
Well, being that this morning's motion was set for 15 minutes, we're now a couple minutes over. I know we're pushing against your next, and opposing counsel is talking about having an expert. We may need to go for 30, but if that makes it harder to get on the docket, I am amenable to squeezing it at 15. And I certainly am agreeable to do everything we can to move this forward. We would be willing to attempt mediation in the next 30 days if Mr. Twombly is agreeable.
Sure.
You want to, is that potentially fruitful, Mr. Twombly, before we address the abate issue?
I always think mediation is a good option, even
Okay.
if it doesn't seem so at the outset. It tends to work.
I'm obviously hugely supportive of it. I just, I can appreciate that the motion to abate is a big swing from best case scenario to worst case scenario, and sometimes that prevents a meaningful mediation because one side's convinced that they're going to win the big one. So
I'm never convinced of anything anymore.
I appreciate that. That means you're an experienced lawyer. What I think I'd like to do then, I'm going to have my assistant in touch with the three of you to get the motion to abate set down for a 30-minute evidentiary hearing in approximately 60 days. You all will be diligent on the bank subpoena, and also if you'd like to try to engage in a mediation between now and then. Of course, I'm supportive if the parties want to see what happens in the abate. The trick with that, of course, I can appreciate if I grant the abate, then it does send plaintiff all the way back to square one. It potentially avoids the entire litigation, and mediation after that might be meaningless. So I can appreciate maybe while the question is still pregnant, the mediation is maybe the best time to do it, because the possibility that the suit gets set over, or the possibility that what might be the strongest argument for defense gets overruled. Maybe you're right. Maybe mediation now is helpful. So I'll have my assistant work on setting that, and I'll probably incorporate with that 30-minute hearing. I might make it 45 and incorporate a judicial status just so we can talk a bit more. Mr. Baer, any other thoughts before I let you all sign off?
No, Your Honor, I know you have another hearing to get to, so I won't address the issues that were not really pertinent to this hearing that Mr. Twombly brought up earlier.
And I'll ask you to get me the order that grants your compel, reserves on the sanctions, and gives the 45 days to comply with anything that's still outstanding.
Yes, Your Honor, I'll have my paralegal send it over to your JA hopefully this afternoon.
Great. Yeah, if you send it in Word, we'll get it right back around to you. Mr. Twombly, anything else we need to address today?
No, Judge, thank you for your time. Joe, if you want to send me some mediators that you guys like, let me know.
Okay.
Thank you, sir.
If you just copy Mr. Twombly on that order to make sure it comports with what we've said and he's okay with it. Ms. Grussell, anything that you want to chime in before I let you all hang up?
No, Your Honor.
Okay, very well. Well, we'll be in touch with all of you to set that motion to abate hearing and a status that'll go with it. Good luck, everybody. We'll try to make it a new day and a productive one. Thank you.
Thank you, Judge. Stay safe.
Okay. All right, and thank you for your patience to my 11:30 parties. I've got Asset Acceptance v. Sprinkle. Who have I got here on behalf of Asset Acceptance?
Jerry Haynes, Your Honor.
Okay, Mr. Haynes. Good morning. And
Good morning.
For Ms. Sprinkle, I understand counsel's on board here. Is that you, Mr. Mummert?
Yes, good morning, Your Honor. Michael Mummert on behalf of Paulette Sprinkle.
Okay, and Ms. Sprinkle's been on the line. I'm going to assume that that is UPSPRI.
That's me, yes.
Okay, and let me do this. Ms. Sprinkle, do you want to raise your right hand? I'll get you sworn in. Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. Mr. Mummert and Mr. Haynes, I know, Mr. Mummert, you got on board fairly recently. Have you all had a chance to have a conversation with each other yet?
We have not.
No, yeah.
All right. Okay. Then we'll build the airplane while we fly it. This is Ms. Sprinkle's claim of exemption, and Ms. Sprinkle bears the burden of proof. So, Mr. Mummert, your client's been sworn. I'll invite you to inquire.
Thank you. Ma'am, can you please state your name?
Paulette Sprinkle.
Okay. And ma'am, did you file a claim of exemption and request for hearing in case number 10CC3590?
Yes, I did.
Okay. And do you recall when you filed that claim of exemption?
I got to get my paperwork. It was in December, I believe.
Was it December 8th, 2020?
Yes.
Okay. And did you have that that form notarized, and in so doing, did you swear to tell the truth on that form?
Yes, sir.
Okay. Are you the head of your family as far as your wages are concerned?
Yes, I am at this time.
Okay. And are you currently employed?
I am currently employed. Go ahead.
Employed by whom?
I'm sorry?
Employed by whom?
I'm employed by Treasure Island Antique Mall.
And what is your hourly rate?
I make $15 an hour, and I work approximately 28 hours a week.
Okay. And do you have a set schedule, or does your schedule vary depending on need?
It's set mostly, but it also can vary depending on need.
Okay. And ma'am, how old are you?
I'm 61.
Okay. And who's that good-looking man next to you?
This is my husband, John.
Okay. And is your husband, does he work?
He does work, but he's been unable to work very much because he was diagnosed with COVID in December, and he's still recovering.
Okay. And I want to go through your claim of exemption. You checked reemployment assistance or unemployment compensation.
Yes. I'm sorry, I lost you.
I have you, but I think
why did you check that?
I was unemployed up until November. So most of last year I was unemployed because my business didn't need as many people.
Hello?
Hello?
Yeah, Mr. Mummert, we're all fine, but I think your connection's not good. I think everybody else sounds like they're okay.
There he is.
All right, okay. I don't know if you lost me or if I lost you at some point, though. I cut out. I could not hear what Ms. Sprinkle said after my last question, in which I asked her if she could explain why she checked the paragraph 6, which is reemployment assistance or unemployment compensation. I hope I don't draw an objection for asked and answered, but I'm only asking this again because I couldn't hear.
Our connection was fine. It was your connection that just froze up on you. So I'll ask her to answer the question, please.
Thank you.
Okay. I was unemployed after our store shut down last year for over 7 months. I returned to work at 28 hours a week, and then I had to take more time off because I was quarantined from COVID. So I'm just getting back to work now. And we're depending on my salary because my husband is really unable to work at the moment or work very much at the moment.
Okay. And is, so are you saying, is your position that your husband is dependent upon you?
At this time, he is, yes. And we use my salary to support ourselves.
How often do you get paid?
Every 2 weeks.
Okay. And what is your paycheck? What's that look like every 2 weeks?
It's a little over 700, about 720 something.
Okay, over 2 weeks?
Over 2 weeks.
Okay, so is it also fair to say that you make considerably less than $750 each week?
Oh, yes.
Okay. Your Honor, that's all. Those are all the questions I have for Ms. Sprinkle.
Okay, Mr. Haynes, any cross-examination?
Yes, just a couple of questions, Your Honor. Ms. Sprinkle, so it's your testimony that that your weekly pay is about $420 a week. Is that correct?
Well, it would be half of 700 and whatever, 720 something. So it would be less than 400 a week.
Okay.
Take home.
All right. And how long you been married?
34 years.
Oh, wow. Good. All right. And you stated that your husband isn't working now.
Yes, he's not, cannot work full time. He does some odd jobs when he feels up to it, but he can't work at a full time rate right now.
Okay. When was the last?
Go ahead.
When was the last time he was employed?
I'm self-employed. So I haven't, I don't, if you want to ask, the last time I got a paycheck was when I was on unemployment.
All right. Ms. Sprinkle, yeah, I don't know, something happened to your light here, but.
There.
That's
Okay,
better.
okay, thanks. So your husband hasn't been able to work for the last, I mean, when was the last time he was able to work? I don't think that was clear.
I am trying,
I'm taking the answer from your husband, but I don't believe your husband is under oath yet.
I was going to ask, would you like me to place the husband under oath so you can just inquire of him?
Yes.
You're a better witness. Sir, do you want to raise your right hand? Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. You can put your hand down and we'll go a little bit out of order, but Mr. Haynes, if you want to just direct exam Mr. Sprinkle, go ahead. I just want to kind of get the information out here.
All right. Thank you. Yeah, let's make it clear before I get proceeded. Okay. Now, Mr. Sprinkle, when was the last date you were employed?
Well, I don't know that you could say employed. I am a self-employed person and have been basically out of work most of this year at my business. And I'm just now starting to get back to it. The business is kind of starting to move again. I got COVID and I was out from the middle of December and have basically just started getting back in. I am fighting a really bad case of fatigue. And I am also having horrible coughing issues, which, pardon me, that's why I'm sucking on a cough drop in the judge's chambers, but that's kind of the direction that it is. I have no idea when I'm going to return back to full fielding. Even when I am working full time, though, our income is so low right now because of the economy and what is going on. Paulette's income is really what we use to make sure that our monthly bills are covered, electric, phone, and that type thing.
Right.
Life has not been good to people in the retail business lately, especially small business. And so I'm kind of at the mercy, and this is our sole source of income at the moment.
Okay. Now, what type of business do you have?
I buy and sell used furniture.
Okay. Do you have a I guess a shop somewhere?
I rent a booth.
I
rent a location. Yes.
Oh, okay. Where's that location?
Treasure Island Antiques.
All right. And I take it you don't have ongoing rent that you have to pay? To keep
Oh,
that
yes,
booth?
I do. I have a lot of ongoing rent. That's why I'm not making money right now. My business is basically, if I'm lucky, I'm going to break even this last year.
Mm-hmm. All right.
And we're hoping that this turns, but there's no promise to that yet.
Okay. And I take it you haven't been able to operate your booth over the last, I guess, this month or last month.
Yeah, I don't operate the booth. I put stuff in it, and hopefully it sells. But the sales have not been supportive of anything. Our income is basically down to Paulette's work.
Okay. All right. Okay. I have no further questions.
Okay. Mr. Haynes, let me just turn to you. Any argument from the plaintiff based on the testimony with regard to the claim of exemption?
Actually, not much of an argument here. It looks like the Sprinkles here have, in tough position. So.
Okay. And that's why I turned to you. Sorry to put you on the spot, but it does appear to me that they've met their burden. So, Mr. Mummert, I don't know that I need to request any elaborate argument from you. The testimony really speaks for itself. I think they've established that at this moment in time, Ms. Sprinkle has had a household and is supporting one or more dependents in the household and makes below the threshold. Mr. Mummert, I typically have an order that I keep for this purpose. Is there anything else that you wanted to state before I let you guys go?
Just my shortest closing argument ever. 4 words, please grant your honor.
Okay. Well, I will do that. And like I said, Ms. Sprinkle, I'm going to imagine Treasure Island is not a huge corporate conglomerate, but is a local small operation. I am, Mr. Mummert, you filed the notice of appearance. I think my assistant saw it come through. I have an order that she's already prepared for me that I can, with a few clicks, sign and file. So I will do that. It will state that Ms. Sprinkle has met her burden, establish that she is exempt, and will dissolve the garnishment and direct Treasure Island to return to you any funds if they've been withholding funds from your paycheck. It's possible that they haven't been, but if they have, it would be dispersed to you immediately as quickly as Treasure Island can act on my order. But Mr. Mummert and Mr. Haynes will have my order in just a few moments. And what I will further note, Mr. Mummert, you can further explain, this indicates that the exemption, the garnishment will go away, the judgment remains, the debt remains. And so if either now or at some point in the future, the Sprinkles become able and become interested, you're always welcome to talk to the other side to see if you're able to negotiate some sort of a payment plan so that you don't get a surprise attack like this. That's really what the law sets up for plaintiffs. It will give you some predictability, but now may or may not be a good time to discuss that. Mr. Mummert, I leave them in your capable hands to further explore that if they're interested.
Thank you, Your Honor.
All right, so with that, I thank both sides for their patience this morning. I'll get the order out in just a moment. I do have to step out and address something. but I will get that order out shortly to both counsel and wish both sides good luck. I know it's a difficult situation. Everybody's doing their best. So good luck. Hopefully things will brighten up here soon.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you.
Thank you, John.
Thank you.
Okay, everyone, that'll conclude our morning session. Thank you. Stay well.